Welcome to a session of oral argument with the 5th ECA. I'm Judge Lambert. I'll be presiding this morning. We have one case. On the panel with me, as you'll see, are Judge Harris and Judge Sasso. Again, we have one case. It's Justin Munoz, M-U-N-O-Z v. State, case 5D20-616. Remember, we are streaming live on YouTube, so anything you say can be heard by people, so just keep that in mind when you're arguing or speaking. This is a criminal case. Each side has 20 minutes. You'll see the clock up in the upper left-hand corner. Mr. Pinnell, if you want anything other than 5 minutes for rebuttal, let us know and we'll set the clock accordingly. That said, if there nothing else, I guess we're ready to proceed. So Mr. Pinnell, whenever you're ready, go right ahead.
Good morning. May it please the court. My name is William Pinnell and I represent Justin Munoz, the appellant in this case. Please reserve 5 minutes of my time for rebuttal.
Good deal.
As noted in our briefs, it's our position this court should reverse Mr. Munoz's conviction for 3 separate reasons. It's our position that both individually and cumulatively the errors of the trial court require reversal in this case. I'm going to start by focusing on issue 2 of the briefs, but will answer questions on any of the issues and address the other issues if time permits. It's our position that the trial court abused its discretion in this case by failing to grant a mistrial when the state introduced a jail call, which included statements from Mr. Munoz that indicated he had a criminal record and that he was seeking the assistance of an attorney, as is his right under the Florida and United States Constitution. As this court has said in Walcott back in 2001, it's well established that a defendant's prior arrest record is not admissible at trial, and the improper introduction of a defendant's prior arrest is presumed to be harmful. The 3rd DCA in the Willis case said that, quote, a motion for mistrial almost always lies upon the introduction of such evidence at trial, and the error in denying necessarily constitutes reversible error. And this court in Walcott cited the Willis case with approval subsequently. Here, despite the defendant's objection, the state introduced a recorded jail call where Mr. Munoz compared himself to the other individuals that had been arrested and indicated that, unlike himself, they all had clean records. It's our position that that statement revealed to the jury that he had a prior arrest history and that statement should have been redacted from the audio recording in this case.
Can you address the scope of the mistrial in your argument on appeal as to whether it's just criminal convictions or whether it's also references to counsel and the preservation issue that's raised in the answer brief and noted by the trial court? Sure.
I believe the mistrial issue addresses both the collateral crime evidence and the defendant's efforts to get an attorney. Those issues were addressed in the initial objection to the video after the audio after the proffer, and the trial court acknowledged and addressed both of them when finally concluding that the motion for mistrial would be denied after initially reserving. So clearly the reason for the contemporaneous objection rule is to put the trial court on notice and give the trial court an opportunity to make a ruling on a particular issue and not play gotcha and raise it for the first time on appeal. Here it's clear, if you look at pages 475 to 480 of the trial transcript, that in determining ultimately to deny the motion for mistrial, the trial judge addressed both the request for counsel and the collateral crime reference in the audio recording. So it's our position that both of those were included in the motion for mistrial. Both of those were certainly considered by the judge when he made his ruling. So there's no preservation issue in this case.
Mr. Pinnell, explain to me how the request or the statement on the tape about your client trying to find an attorney or seeking help trying to find an attorney, how that is an issue.
Okay. The courts have uniformly said that anytime a defendant is indicating his desire for the assistance of an attorney, that's essentially the equivalent of invoking the right to remain silent or a comment on the right to remain silent.
Well, do they say any time a defendant does that, or if he does it during interrogation? I mean, the cases that you cited are all statements made by the defendant to law enforcement during custodial event.
I agree. I agree. Go ahead.
Isn't that a distinction? I mean, in this case, your client wasn't in custody, wasn't during custodial interrogation. He voluntarily made a statement to somebody on a line that he knew was being recorded that he wanted some help finding an attorney. Are you saying that's the same as saying stopping an interrogation, saying, I don't want to answer this, I want a lawyer? Those are the same thing?
Well, first, I would agree all the cases I cited are during an interrogation. But I think I would argue they are the same thing. And none of those cases limit it to interrogation statements. The net effect of a statement, the admission of this statement, is to provide, and what the Carr case and the Janiga case say is the jury may infer guilt from the defendant's silence or unwillingness to proceed without an attorney. And essentially the only relevance I could glean from introducing this evidence, I don't know how this would support the state's evidence or on any of the elements of the charged offense, the fact that he was seeking out an attorney. The only relevance is to argue to the jury or infer to the jury that there's a consciousness of guilt because he's exercising his constitutional right to seek out counsel. So I hear what the court is saying, but I don't understand. I'm at a loss as to why this was relevant for any purpose, why it wasn't redacted, why the state wasn't on notice that they should have redacted, that they're aware of the law, just like defense counsel. And the danger is that the jury is going to believe that because the defendant is repeatedly and I guess kind of over and over again asking the person he's talked to help him find a lawyer, that the jury may infer that he's guilty because he's so worried about having a lawyer. And it's the same thing as when you're being questioned.
That seems to be markedly different than stopping an interrogation and saying, I don't want to answer these questions until I have a chance to speak with my lawyer. This seemed to be extraordinarily different. This is a voluntary, I mean, he could have confessed to the entire crime on this phone call. That comes in. How come a statement saying, hey, I might need help finding a lawyer is so prejudicial to your client when he voluntarily made the statement to somebody other than law enforcement?
I don't think the issue, Your Honor, is voluntariness. I think the issue is whether it's relevant and whether its probative value is outweighed by the prejudicial value. And I'm struggling to find any probative value of the introduction of those statements. And the prejudicial value is the same. The jury may infer guilt by the fact that he's seeking out a lawyer to defend himself because he doesn't want to proceed without the assistance of counsel. Of course, the state an admission would be admissible, but that's not what we have here. We have a defendant exercising or seeking to exercise his constitutional rights, and for some reason, the state found it appropriate to introduce that to the jury for some unknown probative reason.
Did they give an explanation as to why they were? I mean, your client, the trial attorney wanted to redact it. What was the state's response as to why that should not be redacted?
The state initially said that they were introducing the call to show some link between Mr. Muniz using some social media accounts because there was some relevance to that, but the actual references to the social media accounts were separated in time during the call. So, and it ends up being a very short call where most of the call is the discussion of his prior record and him seeking out counsel. And so the fact that he has a prior record and that he's seeking out diligently and looking hard for a lawyer is emphasized and exacerbated by the fact that this is such a short call and there's really nothing else relevant on it. The state says there's some minor relevance, but then when the trial judge later pushes them as to whether they would be prejudiced by this redaction, they admit they would not be prejudiced. So essentially they concede that they should have redacted it in the first place. So it's our position that both the evidence that he had a prior criminal record and his repeated requests for assistance in obtaining counsel were prejudicial. The short nature of the call.
What was the specific reference to his prior record in his phone call? I mean, he talked about an arrest, which seemingly he'd be talking about the arrest here, which is obviously self-evident since he was in trial for committing a crime.
So he says, quote, no, nobody had never been arrested. I was the only one. Like they were all clean records. So by referring to the other people having a clean record and distinguishing himself for that, it's to me obvious that he's saying he does not have a clean record. So the record is to me in the past tense and suggests that he has a criminal history. And again, this is a very short phone call and there's very little, if any, relevant information on it. So the only thing the jury takes out of this is this guy has a criminal record and he's making significant efforts to hire a lawyer because he may have some consciousness of guilt. So it's our position that under the facts of this case, and because there's multiple references to a lawyer and reference to a prior criminal record under the case law, including Walcott, which says a motion for mistrial almost always lies. Willis, that a motion for mistrial should have been granted. I don't think the state is established that this is a situation where a motion for mistrial should not have been granted. So we believe
you don't have any cases that say that a defendant's request or statements about hiring an attorney is reversible if it happens, outside of the custodial interrogation. There's no cases on that, right? You're asking us to fall that far.
Judge, I couldn't find any cases that say yes or no on that subject. So again, I think it's the same danger that the jury might infer guilt because he's seeking out counsel. Again,
your argument, it infringes on his right to remain silent. That's what I mean. To paraphrase the great Ron White, we all have the right to remain silent. Some of us don't have the ability to. I mean, he said this statement. It wasn't elicited from him. He just volunteered this. I don't know how that is a comment on his right to remain silent.
Respectfully, Your Honor, I guess I'm lost on why it matters whether it's voluntary or not. I mean, the statement's voluntary. It's either relevant or prejudicial, whether it's voluntary or not. So again, it's prejudicial. Again, there's no distinction in these cases or no part of these cases that say it's limited to interrogation. He has a right to seek out counsel. There's no relevance, and there's a danger that the jury is going to infer guilt from the fact that he's seeking out counsel. So we'd ask the court to reverse on that basis. On issue one, it's our position that the trial court should have suppressed both the out-of-court and in-court identifications of Mr. Munez based on a suggestive lineup. It's our position that, and this court and other courts have repeatedly said that a lineup is unduly suggestive when one of the participants stands out more than the others. The trial courts made in our opinion, proper conclusion that the tattoos on his neck really jump out as clearly visible on his neck.
But doesn't the suggestiveness then have to lead to a substantial likelihood of irreparable misidentification? And the victim recognizes your client because he sold dope to him, and he's seen him around, and he knows his nickname, I guess, of Peso. I mean, so why are we now believing that there's some substantial risk of or likelihood of irreparable misidentification when he clearly acknowledges I sold dope to the guy within the last month?
Well, because this is a situation where it was a very short encounter. It was less than the total of 5 minutes. Some of the other cases involve a 30-minute encounter. Mr. Lynch testified he could not see the face of the perpetrators when they barged into the back of his apartment, and he was only able to observe the perpetrator in the kitchen for 30 seconds. And
No, that's not exactly what he said. He couldn't see them when they were outside the apartment. When they barged in, he got a good look at them. Isn't that what he said? Your brief says what you just said, that he could not see them when they barged in, but that's not his testimony. He saw them when they barged in. He couldn't tell who it was when they were outside, but when they came in, he saw them for a good 30 seconds right there.
okay, well, at the time they barged in, it's my understanding of the record that he did not see them. The next sentence of my brief says he was able to observe them in the kitchen for approximately 30 seconds. So I agree with that part.
That's a short period of time. I would suggest that if we did not talk for the next 30 seconds and you just stared at us, that would feel like an eternity. Are you suggesting 30 seconds is too short a time to see somebody's face?
I say it's a short period of time when there's guns involved and it's a very stressful situation. And that's what the cases talk about, including the Judd case, that when it's an emotional and stressful situation, the identification is less likely to be accurate. And we have
there were some other differences. Judd was dimly lit. Judd, the victim, had been drinking, and in Judd, the victim did not make an in-court identification. Those aren't our facts.
Sure, but one of the facts in Judd and one of the reasons in Judd was that it was an emotional and stressful situation. And certainly, if you're in your home and someone barges into your house and points a gun at you, and then as you're walking up the stairs, hits you in the face with the gun and tells you to turn around, that's going to be an emotional and stressful situation. So, of course, the facts are not identical to Judd, but I think there's some similarities. And so as he's walking up the stairs, he tries to turn around to look, he's hit in the face with a gun. And again, the whole incident lasted no more than 5 minutes. Most of the cases cited by the state are 30 minutes or much longer than 5 minutes. When he was shown the lineup, despite the fact that he's knows this person or says he knows this person so well, it took him 20 to 30 seconds before he was able to pick Mr. Munoz out of the lineup. So it's our position that under the second prong as well, the court should have suppressed the in-court and out-of-court identifications, and I'll reserve the rest of my time for rebuttal.
Okay, very well. All right, Ms. Davenport, whenever you're ready, counsel, go ahead.
May it please the court, my name is Chris Davenport and I represent the state of Florida. I will start with the mistrial motion. First of all, as a preservation, the actual motion was made on pages 280 to 298 of the record. And when you look at what the argument was by the defendant there, it was all about the arrest. He never mentioned the lawyer issue. The lawyer issue he mentioned before the tape was admitted, but not during the mistrial motion. When the court ruled on that motion later on in the trial, which starting at page 471 of the transcript, the court brought up the lawyer thing in the context of, you know, the state agreed that one way to help remedy this problem was to, if it was replayed, the phone call, that they would redact it. And that's when the lawyer thing came up and they said, well, we'll take that out too. As far as the relevance of the statement about the lawyer, this was in the context of the defense at trial was that this was a misidentification. And one of the ways that they proved his identity was through his social media accounts, because the victim knew the defendant as Peso. So the state introduced evidence that his Facebook account, his nickname was Peso, and his Instagram and emails were Peso as well. So they needed to tie the defendant to his Instagram and to his social media. The lawyer thing came up. The defendant was talking to his friends and said, I know some people who know good lawyers, but I only can reach them through Facebook. So put this on my Facebook wall. That's why it was relevant. As far as the prejudice from the lawyer information, the prejudice from asking for a lawyer during an interrogation is we're afraid that juries assume if you have nothing to hide, you're going to talk to the police. Just like we're afraid that juries might assume if you have nothing to hide, you're going to testify at trial. So we specifically instruct them that you can't hold that against somebody because it's a bit of a foreign concept to a lay person. I mean, it certainly makes sense to us as attorneys, but it's something we need to tell them about because it's a little contrary to common sense. In no way would a common sense layperson think, gee, you're arrested and in jail. You must be guilty if you're looking for an attorney at that point. I mean, that's silly. Of course, at that point, you're going to look for an attorney. And of course, he found attorneys. They were representing him at trial. He had two of them. If it's prejudicial for him to say, I'm going to find an attorney now that I've been arrested and I'm sitting in jail, then maybe we should hide their attorneys at the trial too. I mean, that's how ridiculous that is. It's just a totally different concept than invoking your right to counsel during an interrogation. So we would submit that the trial court correctly concluded that that could come in and mitigated any damage by preventing that from being replayed with the state's agreement. And by the way, the jury never asked for it. Nobody mentioned these phone calls during closing arguments. We're talking about a couple of seconds during a trial that had several witnesses, and it certainly didn't warrant a mistrial, which is a pretty high standard.
Do you concede? I mean, I understand why they wanted to have the call into evidence for other reasons, but do you agree that really any mention about, can you look for an attorney on Facebook or whatever they said, or that really doesn't have anything to do with proving the elements of the crime? I mean, and then those things are easily redacted. We do that all the time in criminal trials. That was part of our par for the course. Whenever I was presiding in criminal dockets, you'd have a redaction hearing, for lack of a better term. Always fun way, but
I think they could have redacted the arrest reference. It would have been hard to redact the reference to an attorney because he said that in the context of post this on my Facebook wall. And that was the whole point of the phone call, was the time to his social media accounts. Could it have been, of course, anything's possible. Did it warrant a mistrial that they didn't? And that's the issue here. We would submit that it did not. As far as his reference to an arrest, when you look at how that actually came up, it was when he was arrested. There were a bunch of people in the car, apparently. There was a warrant for his arrest, which the jury found out about in other contexts. And they said, I was the only one who'd been arrested. Like they all had clean records. Now, this is somebody who knew the victim from buying marijuana from him. And by the way, the victim was a marijuana dealer. So nobody here was crystal clean. The fact that he had an arrest record, again, it should have been redacted, but did it warrant a mistrial? We would submit that it didn't. It certainly didn't vitiate his right to a fair trial. As far as the identification goes, this witness got a good look at this person. He wasn't just a bystander. He was being home invaded by this person. He got a good look at him. He recognized him as somebody he had seen a couple times before. The defendant certainly has a unique appearance with his face tattoos, and the victim specifically described a tattoo on his hand, which was verified by, again, his social media pictures. And at trial, he had a similar tattoo. It had been added to change the Mercedes emblem into an Air Jordan emblem, but certainly similar. He knew him before. He was very certain when he saw the photo lineup. All of the things that show there was no substantial likelihood of misidentification. There's no abuse of discretion by the trial court's finding in that area. I would note that the photo lineup has now been put into the record on appeal. And I don't know if it's because it's a copy. Boy, he doesn't pop out to me when you look at that lineup. They all have facial tattoos. The trial court found that his pop, it doesn't look that way from what we can see on appeal, but be that as it may, there was certainly no substantial likelihood of misidentification. And I would also note that the victim and his friend identified the defendant in court, knew his name. The name was tied to the defendant. The defendant sent a message on Facebook to his friends talking about robbing a marijuana dealer within 36 hours of the robbery. So there was a lot of evidence here, and we would submit that even if that shouldn't have come in, and it certainly should have, that any error was harmless.
Could you briefly talk to the jury instruction issue that Mr. Pennell raised?
Sure. First of all, it wasn't raised below, so of course we're talking about fundamental error here. The first time they defined burglary, they just said you have to have the intent to commit an offense inside the dwelling. The next two times, as they explained what intent meant in more detail, they used the correct language, intent to commit a crime other than burglary or trespass. So the jury was told two times correctly and one time vaguely. It's not like they were affirmatively misadvised that it could be burglary and then told, no, it can't. They were, the first time was vague, the second time and the third time clarified that. Given that the third time is a charm, they had to be told 3 times. I don't think that's what the standard is for fundamental error. If this was something they were worried about, they should have objected below. It's easily corrected. It certainly does not rise to the level of fundamental error. If the court has no other questions, we would ask you to affirm. Thank you.
All right, thank you, counsel. All right, Mr. Pennell, you have 346 left, sir.
Thank you, Your Honor. May it please the court. I would note if the court looks at page 268, there's multiple references for Mr. Muniz seeking out a lawyer, and none of those are linked to social media accounts. So the state's argument that's why it's relevant doesn't hold water, at least to page 268. On the jury instruction issue, it's our position that the trial court improperly deviated from the standard instruction by not carving out burglary and trespass. That jury instruction was amended in 2013. For some reason, the trial court gave the previous instruction. The case law is clear that this instruction is improper.
But we have cases, though, that it can be cured. In fact, there's a case I think we have, I don't know if it was cited, it's called Stone v. State at 899 Southern 2nd 421, where they reverse for the fundamental error, but then we say, this error could have been cured by a subsequent instruction which informed the jury that to convict it must find that the unlawful entry was done with the intent to commit an offense other than burglary. Such an instruction in that case was never given. Here it's given. In fact, it's given even better for you because it's an offense other than burglary or trespass. So I don't know that this is your strongest argument, and I know you got to put your arguments forward, but
Sure.
I mean, since it's a fundamental error issue, it seems it's cured that because your instruction that was given in this case says you can't find him guilty. You must find him not guilty if they don't establish that the entrance was done to commit an offense other than burglary or trespass. So if they literally follow the instructions that we assume that they will do, then, if there was no evidence that he committed an offense other than burglary or trespass, then the jury was directed to find him not guilty. Now, granted, it would have been better to also include that in the first part of the instruction, but be that as it may, it seems like it was cured, but go ahead if you want to respond.
Sure, Judge. I think you have inconsistency. I think you have in the actual elements, it doesn't include the burglary and trespass carve out, and then later it does. This court's decision in Field said where the jurors or faith was both correct and in erroneous instructions, there's no reason to believe that they're likely to intuit which is the correct one and which one is the erroneous one. And I'll point out that during closing argument, the state repeatedly cited the incorrect instruction. So it's our position that there is fundamental error here because that incorrect instruction reduced the state's burden of proof. And this was a disputed issue at trial because there was some evidence from the police officers that there was no evidence of forced entry. So there was evidence that these individuals may have been invited to the premises, maybe whether it was for a drug sale or some other reason. But if they're invitees, then it's not a burglary. So the entering with an intent issue is a disputed issue here, also by the fact that they pled not guilty. So it reduces the burden of proof. It's incorrect. It's a deviation from the standard instruction. So under this court's decision in Heathcock, we believe it is fundamental error. And in Heathcock, this court pointed out whether the evidence is overwhelming or not is not relevant to the fundamental error analysis. So it's our position that even if the court does not grant relief on arguments 1 and 2, it should reverse the burglary conviction on the incorrect jury instruction. Thank you.
All right. Thank you, counsel. All right. We will stand adjourned.
Have a good day.
Thank you.